and not necessarily those of this station, its staff, management, or sponsors. Welcome to the Ask the Experts show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good afternoon. This is the Ask the Expert show. I want to thank everybody. Last week we had Pam Bondi and Corey Lewandowski on our show. We had Roger Stone on our show, but I have never seen so many people viewing the show. We had over 50,000 views. And what's crazy is today is like one of our biggest shows, and I'm already seeing the phones are already ringing off the wall. Um, but I want to thank, we're on 1470 AM, we're on 95.3 FM, we're on 96.9 FM, and we're on 103.9 FM. No one can sit here and tell you they're on four different stations but us, the Ask the Expert show. And our show is live. So let's get started. I love this guy. I think he's like one of the funniest guys I've ever met. And I don't even know if he knows he's funny, but he sure does know about community association law. I want to introduce you to Robert Kay, senior partner of Kay Bender Rimbaum. Good afternoon.
Good afternoon, Steve, and hello to everybody.
Oh, I got to make this announcement. Everybody is calling up. They want to know how to watch the show. This is what you do. You go to Ask the Experts, host Steve-O. Ask the Experts, host Steve-O. And if you thought today was going to be a political show, it's always the same show, the first Thursday of the month. Next week will be a political show. This is, and the phones are just going crazy, Robert. It's amazing. But again, go to Ask the Experts, host Steve-O, and you can actually watch the show right now. So, what do you want to do? Should we tell them a little bit about the firm first before we go to the
Sure.
phones? Okay.
Well, Kay Bender Rambam, as many of you know, is a law firm in Florida that handles things that involve community associations, condominiums, homeowner associations, cooperatives primarily. And that's pretty much what we do. We have three offices. Pompano Beach is our primary office, Palm Beach County, and Palm Beach Gardens, and Tampa. We have an office in Tampa as well, handling all the needs of associations, from reviewing your documents and advising the board as to what they provide on any particular issue, addressing covenant violations among the membership, collections of unpaid assessments, assisting with contract negotiation, drafting, construction defect litigation if necessary, general litigation. Pretty much everything an association will deal with on a day-to-day basis is the areas that we primarily practice. We have live people that are always available to assist our association clients, and we pride ourselves on service. Generally, we respond to our calls the same day, or if it's later in the day, or if somebody's not in the office within a day, there's going to be a response to inquiries by email, inquiries by phone. If it isn't the actual answer, it'll be an indication that you'll have it shortly. We try to make our responses in a fashion that's generally understandable by an average layperson. You don't need a special degree to understand what we're telling you. Like many that we've seen out there, that's a common complaint that we see, that somebody gets an opinion letter from their attorney and they need to take it to another attorney to tell them what it means. We don't work that way, as you know.
Yes. Customer service is very important at K. Bender Rimbaum. Again, if you'd like to watch the show right now, go to Ask the Experts, host Steve O, and you can actually watch the show right now live. Very few shows are live anymore. Most of them are all taped.
Can
Let's
also
get
see
right
on
to the.
KBR Legal.
Yeah, that's right. Let's go to our first call, Bob. Hey, Bob.
Oh, hi. In the age of COVID, I hate to ask a question that's not on the COVID, but
We
we
appreciate
are
it.
an adult 55 plus community, and we have a manned gate. And the question is, what can we do at the gate to stop guests from bringing in animals? I understand there's two categories, service and emotional. What can we ask? What documents can we require? How can we turn people away who don't have them?
Well, you're dealing with something that can be very difficult and exposes the association to a lot of liability by setting that type of a situation where at the entry gate of the community, people are being required to show documentation of emotional support animals. Service animals are an area that apply to areas of public accommodation, retail establishments, restaurants. That's not what a community association is. You fall under fair housing. Emotional support animals are the issue that you're dealing with, or other types of general service animals under fair housing. And it's difficult to enforce animal restrictions on guests. Uh, I want to put this in a way that's easily usable within your community, but generally speaking, if somebody comes with an animal, if they're a regular visitor, they can be allowed in with understanding that whoever they're visiting has to provide documentation to the association at some point of the need for an emotional support animal to be visiting the community. You don't want to do it just blocking everyone who comes in, because that will result in a complaint that's filed against you for discrimination, and you'll be spending lots of money to try and avoid extensive penalties in situations where you're really not doing anything that is terribly guilty, but yet crosses the line under the fair housing laws. So in that respect, it's best to be safe and require the owner to provide documentation after the fact rather than on entry. If you have a repeat visitor that continuously refuses to provide the documentation, then you need to deal with the owner through the enforcement powers of the association and addressing the ongoing violation in that respect. I do not recommend blocking people at the gate into the community.
So you're
Robert,
saying that after the fact we should contact the owner that requested
That's being visited, and
So-
tell them that they need to provide documentation of the need for the animal that's adequate under the law, which I assume you have in place for those who are residents with emotional support animals. If you don't, you will need to get something in place that people like us in our firm, we provide packages of documents that would be used in that process.
Does that answer your
guest comes in, spends the day, leaves, and then we inform the owner that the owner of the apartment that we need documentation, and they say, well, they're gone. They'll never be back again.
Well, if they're never coming back again, then there's nothing you can do about that.
Well, how would we know?
Well, do you keep records of people that come and go?
Too many.
Or more that come than go, I guess.
Well, no, they come and go.
If you keep records of visitors, and you can track that aspect of it, then you would know upon a return. But it's not a very strong position you're in to keep visitors with emotional support animals out. Is that something you're seeing a lot of?
Enough that we're having complaints about it and the lack of enforcement.
Well, it is one that poses significant issues to the association in trying to keep guests from coming in that fashion at the gate. There's a lot of diligence required in overseeing visitors with animals when you have an animal restricted community. That it can be pretty extreme. If you want to take the risk and have your association that be subject to possible claims of discrimination, you can require people to provide some form of documentation from a qualified medical provider of the need for the animal to be with that individual at all times, particularly when going to visit others.
Well, we have the ability to notify all our residents of any requirements. Can we by notification in advance that they have to tell their guests who have emotional animals to bring the documentation? Would that cover us?
Only to a point, because the law favors the disabled, not you. So you have to be very careful if you want to avoid being charged with discrimination. If you want to take that risk and the possible expense associated with it, then certainly you can be more strict on that.
Okay.
So the advice really is to back off the whole issue.
It's not a very strong position to be in as the law currently stands.
Got it. Thank you.
All right, Bob. Thanks for listening.
Okay, thanks, Bob. Let's go to Rich before we go to break. Rich, are you there?
Hello.
Hey, Rich.
I am here. How are you?
Good. How you doing?
I'm good. Okay, Robert, I've got a question for you here. I just want to give you a little intro about my background here on the association here before I continue. Our community has been in existence for 17 years. I've been a board member for 16 of those 17 years. Shortly after I joined the board, I was asked to step up and become vice president when the original president left, and the vice president stepped up to be the president. Since that time, that president has sold his home and moved, and we have a new president within the last 3 years. Unfortunately for our community, this president continually violates the bylaws of our community and acts unilaterally and makes decisions to impose her will on the community without including the board members, who really want to have a say on what's taking place in the community. This president routinely meets with this new property management company that we have behind closed doors on her property without the eyes and ears of the rest of the board members being privy to what's being discussed and what's being planned. And things are routinely done that the president of the board wants done because she is enabled by this property management company to do these things because their method of conducting business as a property management company, they have told me that they direct straight with the president of the board, and they're not concerned with the board as a whole. So I told them, well, what is the point of having a board if you're not going to allow the board to have a say in what's being discussed? So what's happening at this point now is that they are refusing to allow us to have our annual meeting, and our board has vacancies on it for over a year now that need to be filled. And they are not allowing us to have board meetings to bring homeowners onto the board to help fill those vacancies. So at this point, I don't even know what to do because every time a board meeting has been scheduled, it's been canceled in the 11th hour or a day or two before. What can I do to force this property management company to allow us to have our annual meeting where we actually vote and elect members to the board.
Did you say yours is a homeowner association?
Correct.
Okay. Oh, it's a little more difficult in your situation to do this without the likely need to engage outside attorney to help you in addressing these violations of the law and likely your governing documents. Most communities, the vast majority, the officers are appointed by the board and can be adjusted at any time as the board may decide. It also allows for board meetings to be called by a certain number of the board members, and if a quorum of the board shows up, the meeting goes forward. You can do it, you can set it up on a Zoom type setting, you can set it up on a physically be there setting. These days, a lot of people are opting to the Zoom setting, but it has to be open to everybody, and you have to be able to accommodate that, and it's difficult when your management company is not cooperating. You'd have to look at your bylaws to see how meetings can be called by board members on their own without the president doing it. It's not unusual for management companies to require in their contract to have a single point of contact, and quite typically it's the president to direct them, but that presumes that the president is in consultation and following the directions of the board, not acting unilaterally as you've described. So
exactly.
it sounds like a situation that's going to require the assistance of an outside attorney and possibly even the filing of a lawsuit to compel them. And that can get expensive to the community as well. But if you're in a stalemate, you may have no choice.
Right, exactly. I've actually gone and I've read the Florida statutes. You know, like I said, I've been a board member for a long time, and I've never seen a property management company in my entire time being a board member that acts like this particular property management company. I've cited to them the Florida statute that says that we are supposed to fill those vacancies, but it makes no difference to them. They most recently replied to an email because we only have 3 board members, which we don't even have a fully functioning board. We have a president, vice president, and a director. So the director of the board, because every time I have asked for a meeting, I have been dismissed outright. And the property manager even came back with a document telling me that, oh, I have an executive order by the city that says all homeowner meetings are canceled. So I guess she thought I wasn't going to read that document, but I did. And within that document, I found that what she said was a misrepresentation of the facts. What it said in this executive order by the city is that any homeowner meetings to be held on city and city property and facilities are canceled. It did not say all. So I called the Federal Emergency Management COVID hotline, and they told me no such executive order exists where homeowner meetings are canceled outright. She dismissed that altogether and still didn't call for a meeting. Then the third member on the board asked 5 times for the annual meeting to be held, which should have been held in February, but she refuses to have the meeting because she knows that we're very likely going to vote the president out and that property management company out. But I mean, we're to the point now where she has said to us, have the members of the community or the homeowners of the community send an intent to run form to me, and I will verify whether or not they're eligible to be board members. And that way we can have a list, a running log of members who are interested in becoming members on the board. And nowhere in the statement that she sent to us even remotely suggested that we were going to be having a board meeting that allowed us to hold elections and add new homeowners to the board. It just said she was going to create a list. So again, now I'm thinking like what you're saying is we're probably going to have to take legal action because they just are not willing to have a board meeting. And we have more people that want to join the board than actually can be on the board, because our bylaws state we need to have a minimum of 3, a maximum of 9, and the people who want to join are more than the vacancies we have on the board. And from what I understand in that instance, you have to have elections to choose the homeowners who want to become board members and directors on the board. But I mean, I don't even know where to go with this at this point. They're saying that we're going to have a Zoom meeting, but I'm not even sure that's going to happen, because, as I said, they keep canceling at the 11th hour or a day or two before. So,
And how many total seats are there on your board?
right now we only have 3, and
No.
we're allowed to have
How many
up to 9,
vacancies?
and we only have a president and a vice president and a director. We lost our secretary last year, and in August of last year we lost our treasurer because she was continually being harassed by the new president. So she sold her home and left, and since that time we have vacancies on our board that should have legally been filled by holding a meeting to fill those vacancies.
How many vacancies?
Well, we're short a treasurer, we're short a secretary.
So you have a board of 5, of which 3 seats are currently filled.
Correct.
So all 3 of you need to be there to have a valid meeting, because your quorum remains 3. You're going to need legal assistance. I don't know that the association has an attorney, but that attorney may be helpful in getting things resolved once you guys bring in your own attorney, but we'd certainly be able to help you if you chose us.
Yeah. Well, I've attended your seminar and I got my certificate there to be a member of the board, as I'm supposed to. I wanted to be in compliance and make sure I was above and beyond what needed to be required to be on the board.
Well, we appreciate that.
Thanks so
Not much more we
Rich.
can help you with right now.
All right. So, yeah, I pretty much assumed that was the direction we were going to go, is that we need to get legal assistance to represent us. But I guess I will try to go along with the Zoom meeting, hope it takes place, and then maybe the other board member and I can handle things properly to get this community back up to, a manner of ethics, because right now what's going on is unethical.
Well, feel free to send us an email at info@kbrlegal.com, and we'll see if we can give you a little assistance that way,
Robert,
too.
give them the phone number also.
The phone number is 954-928-0680 or 800-974-0680.
I'm
Hey,
sorry,
we're
I
gonna
didn't have
go-
my pen in hand. Can you repeat that for me?
Yes.
800-974-0680. Or you can write to us at info@kbrlegal.com.
Who should he ask for, Robert?
Just make it
I'm sorry?
general and it'll get to the right person.
Okay.
Okay. All right, guys, I thank you very much for your assistance.
Thanks, Rich.
I kind of figured that's the way things were going to go. So, again, thank you very much. I appreciate it.
All right. Thanks for listening.
Well, let's go to break. We're running a little late, and we'll be right back. We got some schedules to go over when we come back.
We do.
We'll be right
Lots
back.
to tell you.
K. Bender Rembaum is a full-service community association law firm devoted to the representation of more than 1,200 community associations throughout Florida under the direction of attorneys Robert L. K. Esquire, Michael S. Bender Esquire, and Jeffrey A. Rembaum Esquire. K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. K. Bender Rembaum assists clients in all matters of association representation, including, but not limited to, collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. K. Bender Rembaum also keeps clients up to date on new developments in the condo and HOA law and how they are personally affected by them. K. Bender Rembaum provides prompt, effective, high-quality, cost-efficient, and understandable legal advice and services to a diverse client base. Call K. Bender Rembaum today at 800-974-0680. That's 800-974-0680.
You are listening to the Ask the Experts show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 6 p.m. Now, get ready for more Ask the Experts.
You know, I didn't know our phones have been ringing off the wall here, and I cannot believe everybody wants to know what your website address is so they can watch the show.
Oh, that would be kbrlegal.com.
Yes. Our producer wanted to know what you were giving away. Okay, so
Good information.
Yes, this is the first Thursday of the month. We're on every Monday and Thursday, and the first Thursday of the month we have our K. Bender Rembaum Community Association law firm. Our shows are from 6 to 7, and they are not just attorneys; you're board certified attorneys. Big difference.
We are. Very many of us are. I think the last count was, I think 8 of us are certified by the Florida Bar as specialists in the field of condominium and community association law. So that would be qualify us to call ourselves experts.
If you have a question now, we have one line open. You have a question for Robert, 888-565-1470. That's 888.
Before we forget, let's tell them about the webinars coming up this month.
Yes.
I want to be sure to get that
888-565-1470. So what do you have coming up this month? Is it a busy month?
It is a busy month. All webinars. The first one is Wednesday, September 9th. It's called Creating a Great Future for Your Association. It's going to be at 2 different times on September 9th, from 2 to 2:45 and from 4:30 to 5:15. Our attorney Lisa McGill will be with Robert Nordland and Will Simmons of Association Reserves. That's next Wednesday, September 9th, one at 2 o'clock and one at 4:30. Thursday, September 10th, there's a webinar panel, Association Operations during COVID-19 at 12 noon with Michael Bender and Jeffrey Rembaum joining Craig Vaughn at Castle Management Group at noon to 1 o'clock. Then also on Thursday, September 10th, there's a webinar, Conflicts of Interest, What You Need to Know, at 1 o'clock to 2:10. Attorney Allison Hertz will cover items such as who is authorized to do business with the association and what is a real conflict and when is it only perceived. Important issue. September 16th, Wednesday, webinar, How to Insure Against COVID-19, 12 noon to 1:30. Michael Bender will join a panel with John Moeller at Brown & Brown Insurance and John Paul from Super Restoration. That'll be moderated by David Cohen from ACAM Management. And then on Wednesday, September 23rd, webinar, Jumping into the Present, Why Updating the Governing Documents of Your Association is Critically Important. 1 o'clock, Wednesday, September 23rd. Attorney Emily Gannon will be the instructor. You'll learn about common pitfalls of older documents and more. And then the last one for September, on September 24th, Thursday, webinar panel, the next episode of Association Operations during COVID-19 at 12 noon to 1 o'clock with Michael Bender, Jeffrey Rembaum joining Craig Vaughn of the Castle Group Management. That's at 1 o'clock, September 24th. To see any of these videos, you go to our website at kbrlegal.com, click on the resources tab, and you'll find videos, and including one we did last month on 40-year recertification. You will want to sign up for these webinars, and which you can also do on the website as well.
Okay, got a busy month.
It is a busy month. Wanted to make sure everybody heard all that. You can go to kbrlegal.com/event-calendar, and you can see all the details that I just identified and registration links.
Okay, let's go to our next caller. Ellen?
Hey, good afternoon.
Hi,
Hello,
Ellen.
Ellen.
Thank you all for hosting this really super important forum. And I'm sorry, I can hear myself talking.
Cousin calling.
Wanted to say that I'm a newcomer. This is the first time I've listened to this, and our association is only 8 members. However, our bylaws are from 1984, and my very, I don't know if it's ignorant or not, but I don't know the answer to this question. How do the bylaws from 1984 work with, I think it's the statute 718, is that correct? And which supersedes the other?
Are you a condominium?
Yes.
Okay, well, 718 is the right statute number. That's the Condominium Act. Condominiums exist only because of Chapter 718 of Florida statutes. So most of the provisions in there likely apply to your community. It's a relatively complex issue as to whether the laws of 1984 versus the laws of 1999 or current laws as they've evolved through the years apply to your association on certain aspects of what's in the statute. What they call substantive vested rights are things that the statute would not be retroactive on unless there's certain language in your documents to make it so. So that does take a bit of a legal analysis to tell you specifically whether or not you're supposed to be following the statute of 1984 versus the statute of today. On most instances, your documents are going to be very similar to what's in the statute, although the election procedure you have in 1984 is different than what was put in place in 1992. That applies to all condominiums, and you have to make sure to follow that. Is there something specific that is of a concern to you?
Yes, the term for a president.
Well, the president is an officer, and their term is generally for the 1 year, or they can continue on as the board allows. The board decides who's going to be the officers. The owners, the unit owners, will elect the board members either each year, or depending on your documents, you may have 2-year terms, staggered terms, or some are 1 year, some are the next. But the officers are appointed by the board each year, and they can carry over if the board so chooses. And so the bylaws will outline that for you.
Yeah, and unfortunately, our bylaws literally say that if you're a board member, you can stay on as long as you want.
And that's generally true, although
we're having a problem with that. And we're having a problem with that because our president is not up to speed in following 718. Let's just say that. 123 pages of 718, and I read them all recently.
Well, that sounds like a lot of fun.
Oh, yeah. It was a ball. But, you know,
well,
that
really,
electronic voting, it's...
The first part is the most important for your ongoing operation. The statute was amended in 2018 to provide an 8-year term limit under most situations, which didn't begin to run until 2018. So whoever got on the board after July 1, 2018 could serve 8 consecutive years and then would need to either continue if there wasn't enough other candidates to run, or if that person received more than 2/3 vote of the unit owners. You only have 8 units, so that makes it a little bit limited as to how many can be involved.
Yeah, it's really frustrating because of the small numbers. All right. Well, thank you very much for your help, and thanks again for hosting the program.
Thanks,
All right, thanks for listening.
Okay, bye
so
now.
We have a line open now, 888-565-1470. We also ask you for your questions. I've got 3 or 4 people here who I promised they're listening right now. I promised that we would get their questions out. So this is a political time of the year. What is this is for a condo? Can they fly a flag besides the United States flag?
The statute provides for a specific enumeration of flags that are allowed to be flown without special permission from the association. And they generally do not include political flags. They would be obviously the American flag, the state of Florida flag, certain branches of the military, but nothing in the way of a Trump flag or a Biden flag, or anything like that.
Okay. I know this might be a little lengthy. It might take us up to break. Can you explain the HOA budget process for reserves?
Well, it's not that complex, and so yes, I can explain that. Some years ago, well, it's getting to be maybe 10 now, or slightly more, the HOA statute was amended to provide that in order to have what we call protected reserves, the type that the owners have to vote to waive every year and can only be used for the purpose that they're being held unless the owners vote for a different type, is if the reserves were voted in place initially by the homeowners or was established by the developer when the community was first set up. So generally speaking, if the law came about in 2009, any community prior to 2009, the developer reserves wouldn't have been set up in conformity with the statute, so those likely wouldn't qualify. So then that would take a vote of the homeowners to create this protected reserve category in the budget. Many homeowners associations that never went through this process have line items in their reserve and their budget that they call reserves, but those are not the statutorily protected kind, which means while they're in there and there's money, the board doesn't have to use that money for the specific purpose it was being held. If they need it for something else, the board can do that without going to the owners. So they would need to put before the owners the question of having a vote to establish these statutory reserves. Once established, then they have to keep having them, and the owners have to vote to waive them every year if they choose to do that.
Okay, that was from Jack in Boynton Beach.
Hello,
Let's
Jack.
go to the phones again. We've got Barry. I'll bet you he's in
Barry.
Philadelphia.
Hi, Mr. K. Hi, how are you?
Well, and you?
Good. My question is, can you have an annual election meeting by Zoom only, and there would be a meeting room only to receive ballots or to give out ballots, but no unit owner would be able to attend the meeting. They would have to leave the meeting and watch the meeting on Zoom.
Is this HOA or a condo?
A condominium.
Well, in order to, is this an annual meeting for the election of directors?
Yes.
Okay, well, generally speaking, most of that's going to be by the absentee mail-in ballot method. And what you've described is generally allowed in the law, but not as specific as we would want, because the Condominium Act doesn't have anything that would apply to this. The Not-for-Profit Corporation Act, Chapter 617 of Florida statute, allows for owners to attend meetings remotely under specified conditions that the board has to approve it. Then there has to be a method of authenticating the people that are participating, and they have to be able to actually participate in the meeting both ways. They have to be able to hear and speak and be heard. What you've described, having a place for the balloting to take place, a physical place, would be necessary, because anyone who didn't get their ballot in by mail should still have the opportunity to come to the place and get a ballot and fill it out and cast their vote prior to the commencement of the meeting. So in these difficult times, our opinion is that would be legally acceptable.
Okay. I hope they.
Now, I have to caution that with there has been no established case law by the Division of Condominium through the arbitration section or the courts having addressed this issue, because obviously it's very new and hasn't had a chance to be challenged, to my knowledge.
Okay. Thank you very much. I appreciate it.
Thanks, Barry.
Okay, Barry, thanks for listening.
Hey,
Sure.
give everybody your phone number and your website, and we're going to go to break.
You can find us at kbrlegal.com and our phone number 800-974-0680. That would get you to any of our offices, Pompano Beach, Palm Beach Gardens, and Tampa.
Okay, we'll be right back with more Ask the Experts, Kay Bender Rimbaum. We'll be right back.
Kay Bender Rimbaum is a full-service community association law firm devoted to the representation of more than 1,200 community associations throughout Florida under the direction of attorneys Robert L. Kay, Esquire, Michael S. Bender, Esquire, and Jeffrey A. Rimbaum, Esquire. Kay Bender Rimbaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. Kay Bender Rimbaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Kay Bender Rimbaum also keeps clients up to date on new developments in the condo and HOA law and how they are personally affected by them. Kay Bender Rimbaum provides prompt, effective, high-quality, cost-efficient, and understandable legal advice and services to a diverse client base. Call Kay Bender Rimbaum today at 800-974-0680. That's 800-974-0680.
We are back. This is the Ask the Expert show. We're on every Monday and Thursday from 6 to 7 drive time. And we have some of the greatest local experts on our show. And we're even adding some politicians are calling into our show. But today is the first Thursday of the month, so that means Kay Bender Rimbaum. And I have a few more questions here that I promised people that I would get on the air because we know what they're listening right now. This is Fred from West Palm Beach. He said, we have a great board, but our previous president keeps coming in and interrupts our meetings. What can we do?
Well, having an orderly meeting is important to be able to operate an association, and having constant interruptions from a unit owner, homeowner, obviously impedes the ability of the board to do that. When they're having meetings in the Zoom-like setting, I understand that the host of the meeting has a little more control over who speaks and can mute everybody except who the person running the meeting recognizes. So that's one good benefit of doing the meetings via Zoom. But in an in-person setting, obviously that's something that's a little more difficult to do. If this individual continuously interrupts and causes problems for the meeting to continue, the board does have the option to summon the police and ask that they remove the disruptive person from the meeting, even though they have an entitlement to be there. Now, sometimes the police won't do that because they consider it to be a civil issue and they don't want to get involved. Sometimes they will do it to keep the peace. The other option that takes a little longer is through legal action, bringing a lawsuit against the individual for an injunction to compel that person not to disrupt the meetings, and to, if they're going to attend, they have to do it in an orderly fashion, and if they continue to disrupt, they can be expelled. The last option is the board can adjourn the meeting and end, but then they're not necessarily going to be able to do their business.
Okay. Boy, Dale in West Palm Beach has got great taste. He says, I love your show and your classes. So he's been to your classes. When our board, one knows when their board vets a new resident, can we check tax returns along with criminal background and credit check?
Well, that's an interesting question, only because in the last, say, 2 months, I think it was in July, lower court on the west coast of Florida issued an opinion that judge's belief is that tax returns are an unreasonable request. Now, that's a lower court. It was a county court, not even a circuit court, and it hasn't been appealed, so it's unlikely to get any further than that. In my experience, it's fairly routine for associations doing background checks to include a requirement of tax returns if their documents support the ability to review financial interests of an applicant to be a part of the community. Certainly, their background checks for criminal and financial through general background checks, and tax returns are often considered a supplement to that that's beneficial and shows a better picture of the financial condition of the individual. If the board has that authority in their recorded covenants, the declaration of condominium or declaration of covenants, it's a much stronger ability to do that. If it's just part of their procedures and a rule, it could be subject to challenge these days because it has happened, and there is one decision which is not binding on anybody else to that effect. So one judge on the west coast of Florida thought that was unreasonable. Does that carry over to anywhere else? Unlikely, but there remains the possibility. Our opinion is that it's still a reasonable request.
Okay. Brooke in Deerfield, I'm on my board and we want to change our management company. 3 of the board members are doing the research. We are looking at estimates now. How can we do this legally with 7 board members?
Well, if they have 7 board members, you need 4 of them to make a decision or to have a meeting. If all 7 are present, then they need 4 of them to pass whatever decision they want to make. Majority rules. Now, you'd have to review the contract to see how it can be terminated if you can do it without cause on a certain amount of notice, or if it only can be terminated within so many days of the expiration of the term, which may likely automatically renew. Or if there's material breach, then you wouldn't necessarily have to wait. So there's various issues that you have to address in making that decision. But generally, the majority of the board.
Okay. We've got about 7 minutes. Would you like to go over your schedule again?
Yeah, let's talk
for
about
those
that.
who missed it.
So we have on Wednesday, September the 9th, we have a webinar, Creating a Great Future for Your Association, and we're having 2 presentations on Wednesday, September 9th at 2 o'clock and at 4:30. It's a 45-minute presentation by Lisa McGill, attorney of our firm, with Robert Norland and Will Simons of Association Reserves. Thursday, September 10th, we have a webinar panel, Association Operations During COVID-19 at 12 noon. Attorneys Michael Bender and Jeff Rembaum will be joining Craig Vaughn of the Castle Management Group. You'd want to go to our website and to the event calendar and register for that, as it's hosted by the management company. On Thursday, September 10th, a second webinar at 1 o'clock, Conflicts of Interest, What You Need to Know. Attorney Allison Hertz will cover items such as who is authorized to do business with the association, and what is a real conflict and when is it only perceived. On the following week, Wednesday, September 16th, there's a webinar, How to Insure Against COVID-19 at 12 noon. Michael Bender will join a panel with John Moeller from Brown & Brown Insurance and John Paul from Super Restoration. Will be moderated by David Cohen of ACAM Management. Again, details and registration information at kbrlegal.com/event-calendar. On Wednesday, September 23rd at 1 o'clock, Jumping into the Present, Why Updating the Governing Documents of Your Association is Critically Important. 1 o'clock, Attorney Emily Gannon will be the instructor, and she'll be addressing common pitfalls of older documents and things to do to make them more current. And the last one for September, on Thursday, September 24th at 12 noon, another episode, Association Operations During COVID-19 with Attorney Michael Bender and Jeffrey Rembaum, with Craig Vaughn at Castle Management Group. Also, if anybody wants to see any of our presentations from the webinar, go to our website at kbrlegal.com, click on the resources tab, and you'll find videos, and including one that we did last month on the 40-year recertification.
Do you, we have about a minute and a half left. Tell everybody, because we educate them for the whole hour, and you don't really push your firm, though you're one of the top firms in Florida. Tell people why they should hire your firm.
Well, K. Bender Rembaum, as we've mentioned in the show, is specialists in the field of community association law. We have significant experience. We have board certified attorneys in all of our offices that are certified by the Florida Bar as experts in the field, which requires passing tests, taking continuing education, and many years of experience specifically in this field. We are a service-oriented firm who provides prompt, efficient, and cost-effective legal services to our clients in a way that is readily understandable to them. And we're basically there for them. You call our office, as you know, you get a person. You don't get stuck in a voicemail loop. We don't do that. We are responsive to the clients quickly and efficiently. So all of the things that we hear complaints about from other places, we were the pioneer of deferred billing collection of assessments, allowing associations to use our services without seeing a monthly bill, deferring the fees, collecting against the delinquent owner. And we were the first to provide that in Florida. Now others have tried to follow our lead, but nobody does it quite like us. We have 24/7 access to all of our collection matters on our website to our clients, so they can always know what's going on in all of their matters, and that's very helpful. So
give everybody your phone number.
That's just a good overview. You can reach us at 800-974-0680, or you can write to info@kbrlegal.com.
And Robert will be back with us again next month, first Thursday. Thank you, everybody. Thank you for all the callers. We will see you Monday from 6 to 7. Thanks, Robert.
Thank you, Steve. Be well.
Thank you.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve.